Thank you, Nicole. Hi, everybody. Welcome. Thanks for being here. As I was telling Nicole before we started, I am physically in Lexington, Kentucky, where the wind chill is -0 degrees. So I'm not having a really good day, but it'll be great. Um, I am work for the Burton Blatt Institute at Syracuse University, and one of my projects is the Southeast ADA Center. So, a couple of things before we get started. The first brief disclaimer: this presentation was developed with funds from NIDLR, the National Institute on Disability, Independent Living, and Rehabilitation Research, part of the Administration for Community Living in the Department of Health and Human Services. We're funded in 5-year grant cycles, so we are completing the 5th year of our current cycle. A couple of things to keep in mind. Number one, I'm not offering you legal opinions today. I am offering you informal guidance based upon my understanding, research, and knowledge of the Americans with Disabilities Act. Southeast ADA Center is not an enforcement agency, and any information we discuss today is non-binding on those agencies that do have enforcement responsibility. So today I want to talk about the ADA Title I, but specifically the interactive process. Because what we have found is generally where the accommodation process breaks down is during that interactive process, that employers don't necessarily know what the interactive process what their obligations are when somebody discloses a disability. So that's what we're going to focus on today. So to begin with, as a refresher, um, what is the ADA? Well, it's not a law of preferential treatment. It is a law of equal opportunity. The ADA is a landmark civil rights law that guarantees equal treatment for people with disabilities, as well as people who may have an association with somebody who has a disability. And that does not have to be a family relationship. It could be a friend. For instance, if I believe an employer took an adverse employment action against me because of his or her knowledge that I was friends with somebody who may be HIV positive, for instance, I may have protection under the law. Um, Often people are confused when they think about the ADA. They think about ADA Title III. These are places of public accommodation and commercial facilities. These are stores, restaurants, banks, movie theaters, sports arenas, anywhere the public goes to access goods and services. But really, there are 5 titles. Title I are the employment protection. This is how you get a reasonable accommodation in order to do your job equally with anybody else. Title II are public entities and transportation. So what are those? Those are state and local governments that have obligation under the ADA, as well as public transportation providers. Again, we've mentioned Title III, those places of public accommodation. Title IV, the telecommunications provisions. And so we're talking about closed captioning, TTY, TDD, and other relay services that allow for effective communication for people with disabilities. Title V are the technical provisions, which includes who has enforcement responsibility. Under Title I, the employment protections, that falls to the EEOC, the Equal Employment Opportunity Commission. We're going to look at their guidance today during this presentation. So fundamentally, at its most basic, Title I of the ADA says that an employer cannot discriminate against people who have disabilities in any employment practice or term of employment, any condition of employment, or the privileges of employment. And this covers all aspects of the employment process. It doesn't just mean when you're on the job. If I need an accommodation, for instance, in order to equally participate in a job interview, I may ask for an ASL interpreter, and that employer interviewing me for that job would have to provide that interpreter at no cost to me. So before we can talk about ADA and Title I, we have to define what a disability is. Because disability defined under the ADA is a legal term. It's not a medical term. And the ADA says a disability is a physical or mental impairment that substantially limits one or more major life activity. So you have to have a disability that impacts a major life activity, seeing, hearing, cognition, speech. This is a non-exhaustive list. If it impacts a major life activity, caring for yourself, then you may have protection under the law. We need to keep in mind also that the ADA defines disability differently than other entities. For instance, Social Security Administration has a slightly different disability. Social Security says that disability is the inability to engage in substantial gainful activity due to a medically determinable physical or mental impairment that would result in death or has lasted for a continuous period of no less than 12 months. There's also, each state has a vocational rehabilitation program where you can go to get assistance in going to work. And VR defines disability as a physical and mental impairment that results in a substantial impediment to employment. If any of us in the audience today are veterans, then you may have experience with the Veteran Administration. And the VA has a completely different definition. VA will say that disability is an impairment in one's earning capacity as a result of disease or injury. And in this scenario, the VA says you don't actually have to prove any loss of earnings to qualify for a VA disability benefit. So two veterans may have heart disease, but they might not necessarily receive the same benefit from the VA. And we need to remember that VA uses a percentage when determining what disability is. So those are some of the different definitions, but for today, we are going to stick with a physical or mental impairment that substantially limits one or more major life activity. And we need to keep in mind where this comes from because the ADA is passed in 1990, yet that definition comes to us from the Rehabilitation Act of 1973. As I mentioned, you have to have a disability that impacts a major life activity, but there are two other prongs of disability determination. The second is you could have a record of having a disability. So, for instance, I may have had a substance use disorder at one time, and I have successfully completed treatment, and I no longer have involvement with my addiction. Yet an employer finds out that I at one time had that addiction, and they may take an adverse employment action against me. Should they do that based upon their knowledge of my record of having a disability, I would have protection under the law. The third prong is being regarded as having a disability, and this focuses less on an actual impairment, but more on the perception that people have about you. You might remember at the Oscars a few years ago, Jada Pinkett Smith is the butt of a very cruel joke because of her alopecia. Well, alopecia does not impact a major life activity, but that joke was rooted in the perception that other people had of Jada Pinkett Smith. And so, under that scenario, she was being regarded as having a disability. Now, there's some exemptions to the ADA that you need to be aware of. The ADA federal law says that private employers with 15 or more employees need to comply. So if you are 14 employees or less, you do not have to comply with the federal law. But keep in mind, California, for instance, will say that private employers with two or more employees would have responsibility to ensure equal opportunity. The second is the federal government. Now you're scratching your head and you're saying, wait a minute, this is a federal law. Why does the ADA not apply to the federal government? Well, think back to what I said before, that the ADA is rooted in the Rehabilitation Act of 1973, and federal responsibility for guaranteeing equal opportunity is found in the Rehabilitation Act. Third, those corporations that are fully owned by the US government. So this could be the FDIC, for instance, or it could be the Postal Service, are exempt from the ADA. Private membership clubs are exempt, and I don't mean like the Kiwanis Club or some social group, but we look at how exclusive the membership of that organization is, and that dictates whether it is a private membership club. U.S. government executive agencies, we've already touched on that. The 573 tribal nations in the United States do not have to comply with the ADA. However, in 1990, the Oglala Sioux um, adopted the ADA as tribal law. Finally, businesses that are operating in foreign countries, if that business would somehow violate a foreign law, then there would be an exemption from the ADA. So, in order to get protection under the law, you have to be what's called a qualified applicant. And an employer cannot discriminate against a qualified applicant. So, what do I mean here? To be qualified, you have to have the skill, the experience, the education, or some other job-related requirement in order to do that job, or that you can perform those essential job functions with or without a reasonable accommodation. We put it right on the job application, right? Can you perform the essential functions of the job with or without a reasonable accommodation? You never have to disclose your disability to an employer unless you are seeking a reasonable accommodation. It is always your decision. And we need to keep in mind that disclosure of disability is a very personal decision. It comes with some benefits, but also some risks when you disclose your disability. But now I'm going to contradict myself and say there may be situations where self-identification might be beneficial to you. For instance, if I'm a veteran and I know that the employer that I am applying to gives preferential hiring under an affirmative action program to disabled veterans, then it may be in my best interest to disclose that disability. Also, there is a section of the Rehabilitation Act called Section 503 that is monitored by something called the Office of Federal Contract Compliance Programs, or OFCCP. And the OFCCP said that if you hold a federal contract, you need to be looking toward a 7% utilization goal, that 7% of your workforce are people with disabilities. It's an aspirational goal. So, anytime we change the work environment for the benefit of somebody with a disability, maybe in the way things are done, that results in that equal opportunity, then we have provided a reasonable accommodation. Now, a business has to make a reasonable accommodation to a known physical or mental impairment, unless doing so would cause an undue hardship for the business. And you might notice in this slide that known is capitalized because, again, that goes back to disclosure of disability. Unless a disability is obvious, you may have to disclose that disability. I've known a lot of employers In the 46 years I've been doing this, I have never known one employer to be a mind reader. So you would need to disclose that disability. So here's some basics to the accommodation process. Under the ADA, under the federal law, there is no standardized form or basic information that you would need to provide. In fact, you can make that accommodation request verbally. You can send an email, you can do it in writing. If you have a voc rehab counselor, they can represent you, for instance, and make the request for you, or your attorney might be able to do that. Now, that doesn't take away that businesses have processes in place whenever there's an accommodation request. They should, right? I mean, we need to have some structure and order to things, but fundamentally, according to the ADA, you don't need to, you can, let me back up. You can either do it verbally or written, send an email, or have somebody else make the request for you, and an employer would have to honor that. So when somebody discloses a disability and they're seeking a reasonable accommodation, what are the employer's responsibilities? Well, first, they need to recognize that a request has been made for reasonable accommodation. And I have a couple of slides coming up in a few minutes that's going to illustrate that point for you, that it's not always a black and white situation when somebody makes an accommodation request. Employers are required to begin what's called the interactive process, and this is what we're going to focus on today with that employee. Um, an employer has the obligation that they can confirm the existence of a disability, which means that they can ask for some documentation from you. And we're going to talk in a moment about what is reasonable and unreasonable of an employer when asking for that documentation. And finally, we need to look at is the area of concern an essential job function or is it a marginal job function? Because we only have to accommodate an employee if they are having difficulty with an essential job function. If it's a marginal or tertiary function, we can assign that to somebody else or it can go away. Years ago, I worked for vocational rehabilitation in Kentucky, and we had a lady who worked for us who had a physical disability. And her essential job function was she answered the telephone and then routed calls. She also greeted people when they came in for a visit with their vocational rehabilitation counselor. One of her marginal functions is she had to, and I'm going to date myself here, she had to take mail at the end of the day to a mailbox. In order to do that, she had to cross a busy road with 6 lanes of traffic, which presented a real danger to her with her physical limitations. So, because that was a marginal or tertiary job function, it was reassigned to somebody else. For a while, it was reassigned to me. I'd take the mail to the mailbox. Employers also have a responsibility to investigate solutions. We have someone who is not performing the essential functions of the job. What can we do by way of adjusting that job in order to have that person perform their job equally? Second is the employer needs to implement that accommodation. Third is you need to document the accommodation. And then fourth is to revisit the accommodation. And that's a very important part too, because most disability is acquired disability. And regardless of who you are one birthday, you are one medical procedure, you are one accident away from acquiring a disability. So what may have been a good accommodation. In 2016, for instance, if I have had a greater impact of my disability, that accommodation may not be effective any longer in 2026, and we may need to revisit and adjust that accommodation. Now, we have to remember that people with disabilities are the expert. They are living the experience of how their disability impacts them. So we should always listen to them in that interactive process when we are looking at an accommodation solution. But we need to keep in mind, under the law, the employer makes the final decision as to what accommodation is put in place, so long as it is equally effective to the one that was suggested by the employee. So I've touched on this a little bit. Let's dive deep. What is the interactive process? Well, here are some good points. First, it is informal and collaborative. It's sitting down to a cup of coffee, right? It's having a good faith conversation with somebody about what trouble they are having performing essential functions and what we can do to allow them to do their job equally. The interactive process is information sharing. It is the opportunity for people to be truthful and honest in sharing information that is both true of the employee as well as the employer. The goal of the interactive process is to identify the effective, reasonable accommodation that we can put in place. We don't always get it right the first time, right? Sometimes it takes some tweaking in order to make that accommodation work. But as the Job Accommodation Network tells us, most accommodations cost less than $500, and most accommodations cost virtually nothing. For instance, I have a lady who works for me and she has a psychiatric disability. And she takes some pretty heavy duty psychotropic medications first thing in the morning. Our standard workday is 9 to 5. However, because of that medication, she really needs a little extra time in the morning in order to be ready to go to work. So her day starts at 10, sometimes at 10:30. Now, does that mean she leaves at 5 like everybody else? No, we have adjusted her schedule so that she starts a little later, an hour and a half in some cases, but she's leaving an hour to an hour and a half later in the day in order to get her work time in. And that costs me virtually nothing, right? I mean, the work is being done, it is just being done slightly differently. Here's a video from the EEOC that gives you an introduction to the interactive process.
Once the employee has made the need for an accommodation known, the employer is on notice and the burden shifts to the employer to start what is known as the interactive process.
Put simply, this is the ongoing communication between the employer and employee to determine what accommodations are needed. Employers should begin the interactive process by asking the employee or applicant with a disability about the type of accommodations they need. When the disability and/or the need for the accommodation is not obvious, if necessary, the employer should request reasonable medical documentation related to the disability and how limitations are to be accommodated. Reasonable documentation means that the employer may require only the documentation that is needed to establish that a person has a disability and that the disability requires a reasonable accommodation. In requesting documentation, employers should specify what types of information they are seeking regarding the disability. In most cases, an employer cannot ask for documentation that is unrelated to the existence of a disability and the need for an accommodation, such as a person's complete medical history. After the specific accommodation and effectiveness of various accommodations has been evaluated, the most effective accommodation should be selected. The interactive process does not have to be a difficult one and should not be contentious. The goal is for both parties to work together to find a solution, a reasonable accommodation that meets both the employees' and employers' needs, unless to do so would cause an undue hardship.
So let's spend a few minutes and talk about what the legal framework of the interactive process looks like. And this information comes directly from the EEOC regulations. The first thing the regulation says that to determine the appropriate reasonable accommodation, it may, and that's stress, may be necessary for the covered entity to initiate an informal interactive process with the individual who has a disability and in need of accommodation. So this goes back to that statement I made before when it's pretty obvious what the disability is. Maybe somebody is a wheelchair user or maybe requires American Sign Language to communicate. That's pretty obvious, right? And we don't need to unnecessarily ask for that documentation unless it is required by the employer. But we need to keep in mind that documentation needs to be tailored to the disability and to what needs to be accommodated. With that said, somebody may have two or three different disabilities that impact a major life activity, but only one requires some sort of an accommodation. So an employee is not obligated and should not share information unless it is tailored to the needs of the job based on that disability. Those other disabilities should not even be considered, and the employer is not obligated, nor should they seek that documentation. The process should identify the precise limitations resulting from the disability and what reasonable accommodation might be put in place that could overcome those disabilities. The EEOC goes on to say that it's unlawful to fail to accommodate a known physical or mental limitation unless it would cause an undue hardship. So, this is where we see one of the two places where the process breaks down, and that's a failure to accommodate. Somebody makes an accommodation request and discloses a disability, and the employer fails to act, or they drag their feet and don't move in a manner in an expedient manner. So the EEOC doesn't define what expedient is. It could be a situation like if someone needed a screen reader because of low vision in order to do their work, and like perhaps that screen reader is on back order, and it could be several months before it can be delivered. That isn't a delay in accommodating, that is a delay in the supply chain, and the employer is making a good faith effort to put that accommodation in place. It is also unlawful to deny any employment opportunity to a qualified applicant based on the need for accommodation. So if I disclose a disability and I need an accommodation, I have not been hired yet. Perhaps I want to bring my whole self to the interview. In doing so, if that employer then does not hire me and I believe and I can document it was because of my disclosure, that would be illegal. Now, to me, this is a very, very important slide in this entire process. The first bullet here says a covered entity shall not be excused from the requirements because of a failure to receive technical assistance. So what do I mean here? You can't plead ignorance. You can't say, well, I didn't understand the law, or nobody told me the law as it applied to the interactive process and accommodation. No, that ignorance of the law is no excuse for not accommodating somebody. Now, the second point is important too, is that if the employer makes an accommodation and say the employee disagrees with what accommodation the employer wants to put in place, they can always refuse that accommodation. But if they do so, remember it goes back to you need to be a qualified person. You need to perform the essential job functions. If you um, can no longer perform those essential job functions because you don't have an accommodation in place, then you may be no longer considered a qualified individual. So someone can't in just offhand say, no, I'm not going to accept that accommodation. Have an obligation to try it. Finally, a covered entity is required unless undue hardship can be proven to provide a reasonable accommodation to someone who, and again, this goes back to those three prongs of disability determination, right? So one, you have a disability, or two, you have a record of having a disability. But as the EEOC points out, you are not required to provide a reasonable accommodation to someone who is regarded as having a disability. So only the first two prongs of disability determination can result in a reasonable accommodation. I'd mentioned before that when someone makes an accommodation request, it's not always black and white. And here's a perfect example of this. This is a case about a year and a half old out of Michigan. It's Yannick versus Kroger Company of Michigan. And in this case, Ms. Yannick had been a bakery manager for 15 years, had a good work history. A new manager comes in and starts criticizing Yannick, saying she was not meeting Kroger's standards. Meanwhile, Yannick receives a breast cancer diagnosis, and she is required to take 4 months off of work um, in order to have surgery and recuperate. When she returns to work, the manager is scheduling her at 53 hours per week. And Ms. Yannick says to the manager, I'm struggling. I need some time to get back to normal. Keep that phrase in mind as we go through these slides. I need some time to get back to normal. Well, Yannick eventually steps down. She goes to work at another Kroger for less pay and less authority. So Yannick sues Kroger, saying that they failed to accommodate her disability. And she also claimed that she had experienced an adverse employment action that was forcing her to move to another store, constructive demotion, if you will. So there are a couple of issues before the court. The first is, was an accommodation request made? Remember that phrase, I need some time to get back to normal. Well, the lower court ruled in favor of Kroger. They said, no, she never said, I need an accommodation because of my breast cancer surgery. However, the Sixth Circuit Court, that's the district that I am in here in Kentucky, ruled that the district court was wrong because anybody could reasonably see that Yannick was making an accommodation request to address her reduced or to address her fatigue by working fewer hours. So, if you remember nothing from this, we need to remember There are no magic words in the accommodation process. You don't have to say, I need an accommodation. You could say, I need help. The second issue before the court did Yannick experience disability discrimination? And in this case, the Court of Appeals agreed with the lower court in saying that the manager was operating within her role as a manager and that her actions were not hostile enough to show constructive demotion. Um, the court had previously said that a supervisor's criticism is not enough to show demotion, constructive demotion, and that the employee could not claim constructive discharge every time an employer fails to accommodate a disability. So, in this case, what the court was saying is, yeah, you can be not so great a manager, but that doesn't rise to the level of creating a hostile environment for that employee. Here's another example. This is out of Las Vegas, Clark County Schools. Jones versus Clark County School. In this case, Mr. Jones was a bus driver and he develops an anxiety disorder. And he goes to his supervisor and he says, look, I just can't drive a bus anymore. I need to find another position within the school system. Rather than recognize that his supervisor had a role because the disclosure was made to him, the supervisor said, oh, you need to contact the school district ADA coordinator. Now, in this case, um, Jones sends a fax to the ADA coordinator and said, my doctor told me I need to retire from bus driving due to my disability and medication. The coordinator misinterpreted that fax as a resignation. So Jones sues the school district, and the school said, well, Jones didn't ask for an accommodation from the ADA coordinator, and they moved that summary judgment be denied. However, the court granted summary judgment and said, well, Jones had notified his supervisor, so he did what was required of him. He asked to be transferred to another position, and that the failure of communication between the supervisor and the ADA coordinator resulted in this situation, and that Mr. Jones in this case was not at fault. And again, there are no magic words that trigger the interactive process. So here's some best practices that we want to impart on employers and employees. Employers need to train their staff. They need to look for those subtle uh, cues that someone may need an accommodation, and they need to know what the process is then for the next step in order to begin the interactive process and to get that accommodation. The staff or the employer needs to ensure that staff know how to follow up on that request, and they need to document any conversation they have. Employees have that same responsibility. Document, document, document. If you don't document it, it did not happen. And the employee does need to understand what the employer processes and policies are when they need a reasonable accommodation. So, what does the interactive process look like? Both employers and employees have obligation. The first is you need to be forthcoming with information. And as we will learn in a minute, this is where the accommodation or the interactive process breaks down. Employers may request limited documentation, again, when that disability is non-obvious. We also need to determine what essential function is being impacted that requires an accommodation. We need to discuss in good faith what those accommodation ideas are. And we should always consider the preferences of the employee. If you don't know what an accommodation might be in place would look like, you can always call the Job Accommodation Network, or in California, and I apologize, I didn't change this slide, you would call the Pacific ADA Center, and I will have contact an 800 number at the end that will put you in touch with the Pacific ADA Center. So when does the process break down? I said before, not being forthcoming with information. Here are a couple of cases that illustrate that. The first is Suvada versus Gordon Flesh. In this situation, Ms. Suvada had stage 4 surgical cancer. She had disclosed her disability to an employer. Um, she raised concerns about her treatment that left her with some difficulty lifting boxes. So she asked, are there any easier jobs? So in this case, the supervisor said there were no other easier jobs in her division. Supervisor then asked, well, what are you going to do? Are you going to resign? So she did so, she said, because she did not want to screw over her coworkers. Well, here's where the breakdown occurs. The supervisor narrowly looked at jobs within Suvada's um, division without considering that this was a large company. Gordon Flesh is very, very large, and that they didn't look at other divisions in order to see if there was a job that Suvada could do that was a little easier for her, given her diagnosis. The second case here, we have Ortiz Martinez versus Forensis Health Partners. And in this case, Ortiz had injured her hand while working as a social worker. And so she asked for a leave of absence for sprained shoulder, an arm, forearm, hand, and carpal tunnel. When she returned to work, she reported that she had some lifting restrictions. So the employer, and in this case, did the right thing. They asked for clarification. They asked for documentation. However, in this case, Ortiz Martinez did not comply. They chose not to respond. And in this case, the court said that Ortiz Martinez caused the process to break down because she withheld information, and that employer's request was not unreasonable. So, again, here we have a situation where Gordon Flesh was not forthcoming, or in this case, the employee, Ortiz Martinez, was not forthcoming. The process also breaks down when people do not negotiate in good faith. In this first case, Ramiro versus County of Santa Clara, Ramiro had requested medical leave 3 times. After 3 times, the employer said, look, we need to meet to look at an alternative accommodation. In this case, Romero refused to talk with the employer and started claiming the employer was acting or was claiming harassment on the part of the employer. The Ninth Circuit Court of Appeals said that by refusing to look at alternative accommodations, that Romero was not operating in good faith. Finally, here we have LaFada versus Church of Christ Home for the Aged. In this situation, LaFada was offered a lateral lower transfer. And again, you can transfer to another position, but the EEOC is pretty clear. It needs to be a lateral transfer. You cannot be demoted. So in this case, she was offered a lower transfer, and I may have misspoke there. And she was told that she had to take it or leave it without any further interactive discussion on the part of the business. And the Sixth Circuit, in this situation, said by offering a take it or leave it only option, the employer was not operating in good faith. So, employer rights and responsibilities, again, you have the responsibility to document. You can ask for that documentation when the disability is non-obvious. The documentation has to be job related and of a business necessity. So again, it goes back to what is the impact on an essential job function. Disability documentation must be kept confidential, and by that I mean that you can't put it in somebody's personnel file. It needs to be in some sort of encrypted separate file away from the employee's personnel file. Now, employers do not have to honor an accommodation request first if it creates an undue hardship, if it's too expensive, if it's too complex, if it changes the essential job functions, then that would be an undue hardship. Finally, if it's dangerous or illegal, you would not have to accommodate. Next, all conversations must be kept confidential. Coworkers should only be advised if it affects their ability to perform their essential job functions. Um, if a coworker says, "Well, why is Raul getting special treatment and I'm not?" A good answer on the part of the employer would say, well, we've made this accommodation for Raul to do his job just as we would for any other employee. Now, the EEOC says sufficient medical documentation must be requested when the disability is non-obvious. And we're going to talk about what is sufficient and insufficient in a moment. Documentation should describe the nature, the severity, and the duration of the disability. Employers may ask for qualifying questions. They can ask if that documentation is not sufficient. In that situation, you may ask for additional documentation. The documentation must be related to the disability that requires the accommodation. Now, finally, and this is important, it doesn't necessarily have to be a doctor. It could be someone else who is qualified, and this is important, qualified to make that determination. It could be a healthcare provider, it could be a therapist, it could be a rehabilitation professional, it could be a social worker. They would be able to provide that documentation to you. So, what is sufficient? An employer may ask for sufficient documentation to substantiate the disability and the need for accommodation. They may not ask for unrelated documentation, and this means in most circumstances, an employer cannot ask for someone's complete medical history because that's likely to contain information that's unrelated to the disability or may disclose another disability that employee never wanted disclosed. Documentation is sufficient if it can describe the nature, the severity, and duration of the impairment, the activity or activities the impairment limits, and the extent to which the impairment limits the employee's ability to perform an activity or activity. Sufficient documentation substantiates why the need for a reasonable accommodation is there. Now, it's insufficient if it doesn't specify the existence of a qualifying disability and the need for the reasonable accommodation. It is insufficient if the healthcare professional doesn't have the expertise to give that opinion. You don't want your doctor or your dentist telling an employer about your medical history, right? That is unrelated to your teeth. The information does not specify the functional limitations due to a disability or other factors that indicate the information provided is not credible or that it's fraudulent. Finally, if an employee provides insufficient documentation, an employer doesn't have to provide that reasonable accommodation until they receive the proper sufficient documentation. Finally, granting an accommodation does not result in eliminating essential job functions or reducing the performance standards of the job. So you can't say, that's all right, Bob. You can't do all the job, but you can do most of these essential functions. That's fine. No, that would not be allowed. Also, it doesn't mean you have to reduce the performance standards. Let's say I own Whaley's widgets and we produce 20 widgets a day, and somebody comes to me and says, "Hey, I'm having a hard time getting my 17 widgets done. Or my 20 widgets, I can only do 17." Well, I'm not obligated to say, "No, that's fine. Just go ahead and do the 17 widgets." No, I am obligated to engage in an interactive process to find out why you're not performing 20 or not completing 20 widgets and what we can do so that you can do 20 widgets and perform your job equally with others. Employers can ask about a disability. It's called disability inquiry. These are questions that are likely to solicit information about somebody's disability or related medical condition. We need to keep in mind there are 3 steps in the employment process. The first is pre-employment, pre-offer. So you cannot ask for any disability inquiry during pre-employment because that would result in a disclosure of disability that perhaps somebody doesn't want made. Pre-employment, post-offer disability inquiries are allowed only if all the candidates in that job category have to participate in that same inquiry. This is how employers can ask for drug testing prior to start work, because everybody in that job classification would have to take that drug test. Third, employment disability inquiry can only be made if it's job related and of a business necessity. So let's say I notice that you're not getting your job done, and I may say, I see you're not getting things done. Is there something we need to talk about? Now, keep in mind, the employer or the employee may choose not to disclose. But keep in mind also, if they do not disclose and there continue to be problems on the job, that employee is subject to disciplinary action. Let's say that this employee has had 3 write-ups and they're about to be terminated. And the 11th hour, they say, "Wait a minute, I have not disclosed my disability to you, and now I'm doing so." Well, that's fine. We will engage in the interactive process, but keep in mind any sort of disciplinary action taken against you prior to that disclosure still stays on the books. It doesn't go away. So during disability inquiry, you can ask about somebody's well-being or a non-disability impairment, whether they can perform essential job functions, whether the person has been drinking alcohol. You can ask about illegal use of drugs, and I do an entirely different presentation, be happy to, on how the ADA views alcohol abuse differently than drug use. Employers can ask about general pregnancy information under ADA, but keep in mind there are other laws that may restrict what can and cannot be asked. And they can ask about an emergency contact information. Employers can't ask whether you have a disability or not. They can't ask if you've had any worker comp claims. They can't ask about your medical or ask for medical documentation unless you're disclosing. They cannot ask for your genetic information, and that is covered under both GINA and the ADA. And they cannot ask about your past prescription medication use. So, in summary, we need to remember that both employers and employees have rights and responsibilities under ADA Title I, that reasonable accommodation allow people with disabilities to have equality in the workplace. The law doesn't require specific language to be used when you're making an accommodation. Employers and employees need to operate in good faith. And again, this is the interactive process. And that the employer makes the final decision so long as what is put in place is equally effective to the one requested by the employee. And so with that, here's my contact information. Oh, that 800 number is not on here. I do apologize. If you want to write it down, it's 1-800-949-4232. That will put you in touch with the Pacific ADA Center. If you would like to reach out to me, there's my email, adasoutheast@syr.edu. I invite you to look at our website, ADA Southeast, and there are our socials, and I'll pause to see if we have any questions.
We do have a couple questions. So the first one someone asked is mediation typically an option for any disputes? And if so, would the company hire an independent mediator or would both parties have to share the cost?
There is a mediation that's my training and background. I'm a mediator by trade, arbitration, mediation, and dispute resolution. And the EEOC has a program. They would rather not litigate. They would rather engage in mediation in order to resolve any conflict between an employer and employee. And so there is a mediation program in place at the EEOC. There is also a training program in place at the EEOC. Let's say that they determine an employer may be in violation. There is a training instrument that could resolve that settlement. Now, with that said, an employer can engage an independent mediator if they so choose, or the employee may request an independent mediator, and that is totally within the rights of both employer and employee.
Okay, and then another question, I don't know if we'll have time for it, but this person asked if there could be a few more examples of the difference between being able to perform the essential functions of the job with or without reasonable accommodations versus not being able to. So examples, I guess, when you're
Well,
able to,
yeah, that's opening up an entire can
yeah.
of worms. I think the best way to address that question is to say that you need to be very careful in your job description in determining what are essential job functions and what are tertiary job functions. Again, the essential job functions are the reason why the job exists. For instance, if I do a lot of flying for my job, and so what's the essential function of the pilot is to fly the airplane to keep me safe. A marginal or tertiary function is when I'm getting off the airplane and the pilot, he or she, is standing in the doorway and they say, "Have a nice day." That's a marginal job function. And it certainly could go away if because of a disability I couldn't do that. I mean, there are so many examples I could give. I don't even know where to start.
Okay, that kind of goes into this one a little bit of reducing the job standards. In the example given of the woman that could no longer lift 20 pounds, is a reasonable accommodation removing that job role so she doesn't have to lift the weight, and then they can ask either a named person one, named person two. Is that
That,
something that would be possible?
yeah, there are a couple of ways to approach that. And the first is there is a case. Oh my goodness, I don't remember the name of it. Somebody versus Bilo Foods. And in this case, the guy worked a night shift. He could lift a lot of stuff, but some of the heaviest stuff he couldn't. And he worked with a team of three. And everybody else just jumped in and helped him, right? Because that's being a good human, that's being a good employee. Well, one night, an employee or a supervisor sees these guys helping out and says, "No, you can no longer perform the essential functions because you couldn't pick up that box by yourself." And the courts ruled in favor of the employee, saying it is reasonable. We all seek help,
Mhm.
formally and informally on the job. I mean, for God's sakes, if I have something go wrong with my computer, I'm going to call IT. I don't know how to fix it,
Mhm.
right? Now, the other way to look at that, and I do want to stress this, is to be aware of what job descriptions say. Like, for instance, the ever popular lifting requirement must be able to lift 20 pounds. Well, lift, if I have a physical limitation, I probably am not going to lift, but can I transfer? Can I move? Sometimes it's the inclusive language that we use in those job descriptions. There's more than one way to move a pallet from point A to point B, or a box from point A to point B.
That makes sense. Okay, and then our last question is stuttering ever considered a disability under the ADA, or would it depend on the severity?
It's going to come back to, again, that definition of disability. Does the disability impact one or more major life activity? And if the stuttering is such that it creates a communication barrier, then yeah, maybe it would rise to a level of disability that would be covered under the law. Again, there are no absolutes with the ADA. We have to look at everything on a case by case basis. And in that case, how significant is the stuttering? What communication barrier does it result in?
Okay, I think that's all of the questions that we do have. I just want to say thank you so much to our speaker, Barry Whaley, for such an interesting and important MCLE presentation. Thank you to the participants for attending today. And again, you will receive a link to a survey at the end of this presentation, in addition to this survey as well, if you guys want to take time to scan it right now while we have it on the screen. We greatly appreciate any of you who take the time to fill out both of these surveys and give both of us some feedback on today's wonderful presentation. Thank you
Thank you
all.
all. Yeah, I appreciate it. How many total did we have?
We ended up having 71 people total. So
Excellent.
really great turnout. I think we had around 87 people registered.
Great. Well, thank you. I appreciate it. Invite me back.
We definitely will. Thanks, everyone. That's the end of today's presentation. Bye.
Bye now.
Bye.
Thank you.